appeal in the matter of Tesla Incorporated and another, and Interdigital Patent Holdings and others.
Yes, Mr. C.
My lords, my lady, I appear for the appellants, Tesla. Mr. Raphael KC and Mr. K appear for the second and third respondents, Interdigital. Mr. Nicholson KC and Ms. Pickard appear for the fourth respondent, Avanci. In terms of papers, you should have a core bundle, a supplementary bundle, the authorities bundle, and a supplementary authorities bundle. We have agreed a timetable taking into account the court's indications, and we'll obviously all do our level best to stick to that timetable. The only other preliminary matter is this: there is a small amount of confidential information in the bundles, as the court may have seen, and in those circumstances we ask for a pro tem 3122-2 order in the same terms as was made by the judge at tab 8, page 100.
That order.
I'm most grateful. My lords, my lady, Tesla appeals with permission granted by Mr Justice Fancourt himself. The net effect of the judgment below is that the patent claims were allowed to proceed against Interdigital, but the FRAND declaration claims against Avanci and Interdigital were not. And Tesla submits, in short, that the judge was wrong to prevent the FRAND declarations claim from proceeding together with the patent claims. The FRAND declarations claim is, we say, a perfectly viable claim against both Avanci and Interdigital, over which this court both has and should exercise jurisdiction. And if the position were otherwise, then the situation created is one of, we say, strikingly unfair asymmetry. If an implementer, such as Tesla, wishes to launch a standard compliant product in the UK, but it has been unable to reach agreement with the SEP owner as to the licensing terms and whether they are FRAND, then under the judge's approach, the implementer either has to sit back and wait to be sued for infringement and find out the FRAND terms that way, or else commence what would be, as is common ground, unprecedented proceedings in a foreign court in the hope of establishing FRAND terms in that way. Now, the courts have said on many occasions that the FRAND licensing system depends upon the existence of a well-functioning dispute resolution system. And implementers have been repeatedly encouraged by the English courts to be proactive, to be seeking FRAND licenses in advance of commencing what would otherwise risk being infringing activity. But if they are unable to reach agreement, then they will always be liable to being sued in the UK on a single SEP, which will then, following the Unwired Planet case, usually result in the court determining global FRAND licensing terms. And it is, we say, an inherent or a necessary, or at the very least a highly desirable corollary of that in order to provide a well-functioning dispute resolution, that same implementer has a corresponding entitlement to seek the same determination by the court in an orderly manner in advance of actually commencing otherwise infringing activity in the UK. Now, before I get into the reasons why we say the judge erred in reaching a different conclusion, let me emphasise, by way of introduction, certain features of the background against which this case arises. That background is set out in the judgment at paragraphs 8 to 16 and in paragraphs 13 to 25 of our main skeleton, and I shan't go through all of it, but let me identify some particular features of relevance for the issues in this appeal. First of all, Tesla wishes and intends very soon to launch 5G vehicles in the UK. The precise intended timing doesn't matter for our purposes and is confidential, but is set out in paragraph 2 of our main skeleton and is then updated in paragraph 27 of Hopewell 5. And the UK is Tesla's 4th largest market in the world. Secondly, Tesla pragmatically accepts that in order to sell 5G vehicles in the UK, it will require a license under the UK SEPs in the Avanci pool, which of course includes Interdigital's UK SEPs. Thirdly, all of the patents within the Avanci pool, including all of Interdigital's patents, are patents declared to ETSI and which are therefore impressed with FRAND licensing obligations legally enforceable by Tesla. That's our pleaded case of paragraph 46 of the particulars of claim, and it hasn't been materially disputed. Fourthly, the effect of those FRAND obligations is that the owners of those SEPs, including Interdigital, are contractually obliged to make an offer to license those patents on FRAND terms, which is capable of acceptance by Tesla. The implementer is entitled to a license, as this court has only recently explained, from the first day it implements the standard, provided it undertakes to take such a license. I'll come to the law on that in more detail in a moment. Fifthly, each and every one of the owners of the patents within the pool has appointed Avanci as their agent to make a joint licensing offer under their SEPs on their behalf. Avanci can license the patents either directly within the scope of its authority, or it can do so on the basis of a sub-license. That's Regenda 1, paragraph 10. And the arrangement is described by the defendants themselves as one of joint licensing. And we give you the reference to that in supplementary skeleton at paragraph 8d. Sixthly, Avanci's pool license offers have been repeatedly advertised and represented by Avanci, acting as the agent of the SEP owners, to be FRAND offers. And in this regard, I just want to show the court some examples, please. If we go in the core bundle to tab 18, please, at page 215. This is an extract from Avanci's website. And we can see on the facing page, page 216, we have a whole list of questions, the first of which is what is a standard essential patent? The last of which is Avanci licensing on FRAND terms? Absolutely. Avanci shares a commitment with the Internet of Things ecosystem to make the latest technology available in a way that is fair, reasonable, and non-discriminatory. This well-established industry principle ensures that those using the technology in their Internet of Things products have access, etc. To similar effect, if we go now, please, to the supplementary bundle, some further examples. In tab 3, to start with, these at page 31. This is a press release when Avanci launched its first platform. And we can see in the second paragraph, 5th line, Avanci streamlines this process by offering a single license to patents owned by many companies on fair, reasonable and non-discriminatory FRAND terms. Companies can expect a transparent, flat rate price for each device that will vary based on the value the technology brings to the device. To similar effect, at tab 6 of this same bundle, page 77, this is a white paper, as it was described, regarding the Avanci vehicle platform.
Your numbering on your electronic bundles is 2 pages out, so
I
just
apologise.
takes a little bit more time to get there. That's
And
all.
my lady, if I might ask, in which direction am I out? Do
So
I
when I
need to
tap
add?
in, when you say 77, in fact, it's 79 on my electronic. So I can manage that now. I've worked it out.
Okay. I'm most grateful. And at the bottom of the page, we have that the goal of Avanci's efficient and scalable marketplace is simple, to provide access to the vast majority of the standard, etc. Then we have, this is accomplished by making connectivity technologies available to Internet of Things product manufacturers in one place and in one license, using fair, reasonable and non-discriminatory licensing terms. And indeed, that is how it was put directly to Tesla, as we can see from the next tab, tab 7, which is page 78 in the hard copy and 80 in the electronic. An email from Avanci to Tesla in the context of the 4G negotiation, making a series of points, the third of which, as you can see from the middle of the page, is I wanted to make sure you had an explanation of why our royalty rates are FRAND. And I shan't read the whole thing out, but essentially the justification is by reference to prices for the technology in smartphones. And we see in the last bullet our $15 rate. Now I pause there, that's the 4G rate. The 5G rate has more than doubled to 32. Our $15 rate, which will never increase during the term of the license, no matter how many additional licensors join, is roughly 75% of the appropriate industry-wide royalty and therefore reflects a FRAND royalty. I could go on. We give further references at footnote 1 of our supplementary skeleton. And as regards Interdigital, we give references at footnote 2 of our supplementary skeleton. Let me take you to one of them in tab 9 of this same bundle at page 86 or 88. This is from Interdigital's website. Under the heading Overview, in the second paragraph, we have a sentence which I can pick up towards the end of the first line. Interdigital respects the important role that intellectual property policies serve within the standard development environment. As such, Interdigital honours its commitments under applicable IPR policies of standard development organisations of which it is a member. And then we have listed below that licensees through platforms, and as one will see, they are almost all automotive manufacturers.
Can you help me with why this is relevant?
Indeed. The answer is that Avanci has been appointed as agent by the SEP owners to offer a license. There is no issue taken for the purposes of this jurisdictional argument. That's the arguability of the proposition that in doing so, it is discharging the legal obligations of the patentees. That means that for the purposes of the Vestel argument, which arises on ground 1, this claim is by contradistinction to the claim in the Vestel case, squarely concerned with a pleaded legal right. The problem in Vestel, as we will be seeing, and I'll come to that shortly, was that there had been no pleading of the legal right to a license. In this case, we do. no issue is taken as to the arguability of the proposition that what is being done by Avanti is discharging that right. And we say that fills the missing link that gives jurisdiction properly for a declaratory claim against Avanti, if necessary, alone.
Why is it relevant to any of that that Interdigital is saying that it's, and Avanti is saying that its rates are FRAND?
Well,
I just want to understand the point, because
it's consistent with what we say is the true legal position, and which is, as I understand it, not disputed for the purposes of this argument, this jurisdictional argument, that in offering the licence, Avanti is purporting to discharge the legal obligation of the SEP owners.
It would be very odd if they were to say, by the way, these rates aren't FRAND.
Well, it probably would, yes. But if they said it, then they could be here saying, well, the platform has nothing to do with FRAND. That is not what's happening. For the purposes of this argument, we proceed on the basis that in making the offer, Avanti is purporting to discharge the legal obligations of the SEP owner. And that's the point to which this goes. Indeed, the seventh feature of the background I wanted to stress, which is relevant also to the same point, is that members of the Avanti pool frequently rely, when bringing patent infringement proceedings, upon the fact of the pool licence offer from Avanti as allegedly discharging the SEP owner's legal obligation to make a FRAND offer. And there are a whole series of examples of that set out in Ms Hopewell's evidence in Hopewell 3 at paragraph 17 and 34. It's a point to which the judge makes reference at paragraph 13 of his judgment. I was going to take you to some examples, but I apprehend that it maybe felt I should get on. But as I say, Hopewell 3, paragraph 17 and 34 give you all the examples. And when the SEP owners bring such infringement proceedings, there is no evidence and no suggestion that other members of the pool are joined to those proceedings or anything of that nature. The eighth point of background that I stress is that although the offer is made by Avanti as agent, Interdigital has asserted that it knows very little of how the rate was devised or how it could be justified as FRAND. As the judge emphasised at judgment paragraph 11, the rate offered is Avanti's decision. And Interdigital's evidence in Brody 2 is that it doesn't know sufficient itself to justify the offer as FRAND. That's Brody 2, it's in Supplemental Bundle tab 21, and the relevant paragraphs are 29.2, 75.7, and 90.1. And it's a point emphasised by Interdigital in its skeleton at paragraphs 3 and 16b. Ninthly, and this is the last point of background, Tesla wishes to take a licence to the SEPs. It considers that the rate at which they are being offered is not FRAND. It has sought to negotiate, but Avanti has made clear that those terms are offered on a take it or leave it basis, and so a dispute has crystallised in that regard. And the detail of that is all set out in Hopewell 1 and Hopewell 3. And we say, to reiterate the points I made in response to my Lord Justice Phillips' question a moment ago, that dispute as to the FRAND rate is a dispute as to the effect of a legal obligation attaching to the SEPs, which Avanti has been entrusted to offer for licence as the agent of its members. And so against that background, by these proceedings, we seek to do two things. First of all, Tesla challenges the validity and essentiality of 3 UK patents declared by Interdigital to 5G and which are within the pool. In that regard, this action has the same structure, as we'll be seeing, as was adopted by the claimants in Kaigen and Thales and in Lenovo and Interdigital, and indeed the cases referred to at paragraph 21 of our skeleton, to which I shall come. That's the first thing we seek to do. The second thing, Tesla seeks to establish via the FRAND declarations that the licensing terms currently on offer through Avanci are not a FRAND offer to license those 3 patents, or indeed all of the UK patents in the pool, and we seek a declaration as to what FRAND licensing terms under those patents would be. And importantly, it is emphasised by Interdigital that if the court were to declare that the FRAND terms for the pool are different than those currently on offer, then the continuing members of that pool will very likely cause Avanci's terms to be adjusted. In Interdigital's words at paragraph 17 of its skeleton argument, referring to its witness evidence, it would be untenable for the platform to offer terms determined as non-FRAND against Avanci. In other words, the pool will be required by its members to think again about the rate. This is a point the judge made at paragraphs 94 and 97 of his judgment. It is also Interdigital's evidence in Brody 3 at paragraphs 28, 29 and 39. That is, we say, very clear evidence of a useful purpose to the FRAND declarations. Now, Tesla wanted to resolve this dispute about FRAND licensing terms in an orderly way before it launched 5G vehicles. And these proceedings were therefore commenced very nearly a year ago, on the 5th of December 2023. That is exactly the kind of proactive conduct by an implementer which is encouraged by the courts and which SEP owners have been saying for many years that they would wish to see. Indeed, and we shall be coming to this, Interdigital recently established in this court that an implementer which has not taken a license in a timely manner will generally be unable to take advantage of any relevant limitation period and will owe interest, in that case compound interest, for periods during which royalties have been payable, whichever party was responsible for the delay. That's the decision of this court in Interdigital and Lenovo, to which I shall come in a moment. And it is, we say, as I said at the outset, really a corollary of that approach, as a matter of fairness, that an implementer should be able to bring proceedings in advance of otherwise potentially infringing activity to establish what the FRAND licensing terms which it must take actually are. So we say there really is no basis for cutting off the FRAND declaratory claim at the knees, which is the outcome at present. And the judge very fairly acknowledged in paragraph 123 of his judgment that this outcome might seem odd and had given him some concern. We submit that the judge's concerns were well held, and for all of the reasons I shall be developing today, this is a claim with a very real prospect of success over which the English courts both can and should exercise jurisdiction. With that by way of introduction, I shall be making my remaining submissions under 7 headings. The first is some points about the legal framework in relation to FRAND disputes in the UK. The second is serious issue to be tried against Avanci. That's appeal ground 1. The third topic is serious issue to be tried against Interdigital. That's appeal ground 3 and respondents notice grounds 3 to 6. The fourth topic is the representative status of Interdigital. That's appeal ground 4 and respondents notice grounds 7 to 10. The fifth topic is CPR 63.14 and the gateways. That's appeal ground 2 and respondent notice grounds 1 and 11. The sixth topic is appropriate forum, which is appeal grounds 5 to 7 and respondent notice grounds 2, 12, 13. And the seventh topic is full and frank disclosure, which is respondent notice ground 14. So taking those 7 topics in order, the first is some points on the law in relation to FRAND disputes in the UK. This is, as the judge observed, in fact, in his reasons for giving permission to appeal, which are at tab 12 of the core bundle, a fast-moving and cutting-edge area of law, and is now the subject of a considerable number of decisions. The background is summarised in the recent decisions of this court in Interdigital Lenovo and in Panasonic Xiaomi. And I wanted, for present purposes, there's obviously not time to cover the whole background, I want to emphasise 5 points which are of particular importance to the issues on this appeal, some of which are common ground, some of which are not. The first is that the ETSI obligation requires the SEP owner to make a FRAND offer capable of acceptance. The second is that the ETSI obligation is owed by all entities within the declarant's group. The third is that the FRAND licence under a single UK SEP may extend far beyond that right and may be a global licence under a whole portfolio or a pool. The fourth is that the courts have endorsed the entitlement of an implementer to bring declaratory proceedings to settle FRAND licensing terms. And the fifth is that, and this is a point I was adverting to a moment ago, the proposition in Vestel that there is no such thing as a freestanding FRAND claim refers to a situation in which the claimant, in that case, had failed to plead any relevant legal obligation at all. That's what is meant by a freestanding FRAND claim. So let me develop those 5 points. The first one I can take briefly. It's that the ETSI obligation requires the SEP owner to make a FRAND offer capable of acceptance. That appears to be common ground. That's paragraph 13 of Interdigital skeleton and paragraph 8A of our supplementary skeleton. My learned friend has just told me that, in fact, that's not common ground. So let me just show you quickly the authority on that. It's Nokia and Oppo in Authorities, Volume 2, at tab 31. And this is the case cited by both my learned friend and myself. It is, and and I hesitate to give a page number, but page 982, I'm hoping it's this time the same. I'm looking for paragraph 258 of the decision.
No, it's not. So I'll need the paragraph numbers. 258 is where you want us to get to.
Yes, indeed. And there's obviously a whole analysis leading up to this conclusion, but there's not time to go through it all. In the light of this analysis as a whole, I agree with Nokia that clause 6.1 requires the patentee to make a FRAND offer which is capable of acceptance and actually FRAND. And then the judge explains in practice how it works. In the Patents Court, a FRAND matter such as this comes on for trial with a concrete set of terms of consideration. 260, the court applies the standard of whether the offer was FRAND or not, because it's almost impossible to hit the nail on the head. It's usually found the offer was not FRAND, but the court is able to say what would be FRAND, etc. So, my lords, my lady, the language of requiring the patentee to make a FRAND offer capable of acceptance and actually FRAND, I draw from paragraph 258 there. The significance for present purposes is that the courts do not, at least in ex-FRAND cases, grant orders for specific performance of the licensing obligation. And that's a point we've given you the law on in paragraphs 8a of our supplementary skeleton argument. Rather, they decide whether a FRAND offer has been made, if not, what FRAND would be, and they grant declaratory relief and grant or withhold injunctive relief in a separate infringement case accordingly. So that's the first point on the law. In relation to the second point about the ETSI obligation binding all affiliate companies, you have the ETSI IPR policy in the supplementary bundle, and that's the supplementary appeal bundle, at tab 30, which is page 313 in the hard copy and page 315 in the electronic. And as you will see at page 315 in the hard copy, 317 in the electronic, there is reference to, in 6 bis, to being obliged to use the ETSI IPR licensing declaration forms to make their IPR licensing declarations. We have the declaration in the next tab, tab 31 at page 316 or 318. And we see in the middle under the heading IPR licensing declaration, in accordance with clause 6.1 of the ETSI IPR policy, the declarant and or its affiliates hereby irrevocably declares the following, and then you can see to the extent that the IPR is disclosed, etc., and then at the end of the second line, the declarant and or its affiliates are prepared to grant irrevocable licenses under this or these IPRs. Now, we don't have the definition of affiliate in the bundle, unfortunately, but it includes, as I hope will be common ground, any company under the same direct or indirect ownership or control as the declarant. If there is any issue about that, I can bring the declaration, the definition. And the obligation is drafted in that way to avoid companies shuffling patents around within their group to subsidiaries which did not themselves give the FRAND undertaking and escaping the obligation that way. That's a point, I don't think I need to turn it up, but that's a point that the Court of Appeal made in the Unwired Planet case at paragraph 106. we can see the same point, which I think I do want to turn up in the Unwired Planet case in the Supreme Court, which is in the Authorities Bundle, Volume 3 of the hard copy, at least in mine, tab 50. And it's in the hard copy, it's page 1509. And at paragraph 8, which is on page 1149 of the report, or page 1517 of the hard copy, we see the Supreme Court say the ETSI IPR policy is a contractual document governed by French law. It binds the members of ETSI and their affiliates. Now, in the present case, both D2 and D3 are, as we plead in paragraph 12 of the particulars of claim, under the ultimate ownership of Interdigital Inc. And so, although it is D3 that gave the undertaking, that commitment was given also on behalf of D2. And that is common ground and confirmed in Interdigital's evidence at Brody 2, paragraph 21. So both D2 and D3 owe enforceable ETSI obligations, and there's nothing surprising about that, given in this case in particular, D2 is in fact the owner of many of Interdigital's patents, including all 3 patents in suit. Now, keeping, if we may, Unwired Planet open, that brings me to my third point on the law, which is that the FRAND licence may extend under a single UK SCP, may be one under a whole global portfolio or a pool. That, of course, was the central issue in the Unwired Planet case. It was whether the FRAND licence under a single UK right could extend to encompass a global portfolio. And the Supreme Court held that it could, and indeed did so extend. And in terms of the reasons for that, one of the points that the court stressed was industry practice. And we can see this at paragraph 48. And that's in the hard copy, page 1527, in the report, page 1159. In deciding that a worldwide licence was FRAND, Mr Justice Burse had regard to practice in the telecommunications industry to agreed portfolio licences, and observed that every patent licence which the parties had produced in the trial bundles was a worldwide portfolio contract, although some licences carved out a particular territory while licensing the rest of the world. There's reference to Unwired Planet's portfolio. A willing licensor of such a portfolio and a willing licensee such as Huawei with global sales would agree on a worldwide license. He recorded that it was common ground that the industry assessed patent families rather than individual patents within a family. He thus drew on industry practice in deciding that a FRAND license would be a worldwide license. And the same point about commercial practice came up again in the Supreme Court's decision at paragraph 62, page 1530, in the hard copy, page 1162 in the report. And next to letter J at the bottom of page 1162 in the report, we have, in imposing those requirements and more generally in its requirement that the SEP owner makes an irrevocable undertaking to license its technology, ETSI appears to be attempting to mirror commercial practice in the telecommunications industry. We do not accept the distinction which Huawei draws between voluntary agreements, etc., since the IPR policy envisages that courts may determine whether or not the terms of an offered license are FRAND when they're asked to rule upon the contractual obligation of a SEP owner. it is to be expected that commercial practice in the relevant market is likely to be highly relevant to an assessment of what terms are fair and reasonable for these purposes. And I shan't read the rest, but they go on to similar effect in 62 and 63. So the FRAND licence under a single UK SEP is not constrained by whatever patent right is in suit. The scope is instead determined in accordance with commercial practices in the field. And the courts have since that case applied that same principle to a variety of different situations in which issues as to the scope of a FRAND licence arose. One example, we have the cases in the bundle, is it's been held to be arguable, for instance, that a FRAND licence may include rights of use under non-SEPs, which are also owned by the licensor, if the non-discrimination obligation of the licensor requires it, so that the FRAND licence would have included the non-SEPs. That's Lenovo and Interdigital in Authorities 2 at tab 24, and Alcatel and Amazon in Authorities 1 at tab 3. And secondly, and relevantly for present purposes, the Patents Court has also held that it's arguable that a FRAND offer under a UK SEP may be won under a whole patent pool. That's the Mitsubishi case, which the judge discusses in paragraphs 34 to 35 of his judgment, and which we cite in paragraph 8D of our supplementary skeleton. And perhaps unsurprisingly, no issue is taken with that proposition by the respondents. And as I say, what this means is that an implementer selling a standard compliant product may in principle find itself liable to be injuncted for having refused to take a licence offered through a pool if those terms were FRAND. And that is not, I emphasise, a hypothetical concern. It has indeed happened in Germany to the car manufacturer Ford in a case relating to the Avanti 4G licence, as Ms Hopewell explains in her evidence at Hopewell 3, paragraph 34A, and Hopewell 4, paragraph 19. And my fourth point on the law was then that the courts have recognised the availability of FRAND declaratory claims brought by an implementer. And in the first instance, I would go, please, in that regard, to Interdigital and Lenovo, which is in the authorities bundle at, or the first bundle at tab 19. And it's in the hard copy, it's page 536. And one of the issues in this case is whether, where an implementer had failed for whatever reason to take a license for many years, it was entitled, in effect, to rely on limitation when the court was settling the FRAND terms by saying that the FRAND terms would not provide for payment any further back than 6 years. And the court held that in most cases that would not be the case. We have the ground begins at paragraph 170 at page 596 of the hard copy bundle. Now, before I get into the reasoning on limitation, for the purposes of a later point I should be making, I also draw attention to paragraph 168, which is, in my submission, a helpful summary of the circumstances in which a court of appeal is entitled to intervene in relation to a decision which lay, in principle, within the judgment of the first instance judge. and I shall be coming back to it, but the categories which are given referring to the decision of the Supreme Court in lifestyle equities are a significant error of principle, or if the judge's decision was wrong by reason of an identifiable flaw in the judge's treatment of the question to be decided, such as a gap in logic, lack of consistency, or failure to take into account some material factor which undermines the cogency of the conclusions. That will be relevant predominantly to the later issue on forum conveniens, where my learned friends seek to preennate the fact that, in principle, it's a matter for the judge. Coming back now to the argument in relation to FRAND declaratory claims, we have the heading Lenovo's ground 1, the relevance of limitation. And you'll see the ground in the judgment of my Lord Justice Arnold, summarised in that paragraph. The analysis begins at paragraph 186. And at paragraph 187, in the second sentence, the court emphasises that an implementer such as Lenovo requires a licence from the first day it implements the relevant standards. FRAND terms are the terms that would be agreed between a willing licensor not intent upon hold-up and a willing licensee not intent upon hold-out. The ETSI guide and FAQs page make clear that if a willing licensee, would not sit back and wait for demands from SEP owners, but would proactively contact SEP owners and would put money aside for the payment of royalties. It goes on to observe that the willing licensor and licensee would negotiate a standstill agreement. At 189, we have the point that it follows that an implementer should not be rewarded for delay, whether the delay is the fault of the implementer or not. Now, one of the points that Lenovo made, as we can see from paragraph 200 on page 602 of the hard copy, was that it was Interdigital that was responsible for the delay in FRAND terms. And that submission was not accepted for a number of reasons, the fourth of which is at paragraph 204, and is in my submission clearly part of the essential reasoning of the court. Fourthly, if Lenovo had accepted the need for a licence and committed to take one on terms determined by the court to be FRAND, it could have brought proceedings itself for a declaration as to what terms were FRAND. It did not have to wait to be sued by Interdigital. And those reasons were agreed with by Lord Justice Nugi at 289 and Lord Justice Burse at 302. And we say, if an implementer is expected to seek to resolve FRAND licensing terms before commencing otherwise infringing activity, if it is to be liable to pay compound interest and will be unable to avail itself of limitation defences, if it does not so agree, then it is particularly important that they are able, in the event of a dispute, to bring proceedings proactively to resolve it. Simply sitting back and waiting to be sued is not a neutral act. It carries very substantial negative consequences. And the same point was made in the Panasonic and Xiaomi case by my Lord Justice Arnold. That's in Authorities 2 at tab 35. At page 1067 of the hard copy bundle. In the court's summary of the law in this area, at page 1071 of the hard copy bundle, paragraphs 14 and 15. We see that the courts have sought to persuade parties to agree to the FRAND trial being heard first, because experience to date shows that subject to any appeals, the court's determination is usually accepted by both parties. I pause there to note that, of course, in this case, that is precisely the evidence of Interdigital. They say that if the court makes a determination in practice, it will be followed. Furthermore, in one case, case management decisions have been made which result in the FRAND trial being scheduled before a technical trial. That's the Lenovo and Ericsson case, which we'll be looking at shortly in tab 22. In that case, this solution was advocated by the implementer and opposed by the SEP holder. And we then see in paragraph 15 the reasons for the change in attitude. And 5 lines up from the end, to that end, an implementer who accepts the need for a license to a SEP holder's portfolio and is willing to undertake to take a license on terms determined by the Patents Court to be FRAND can itself commence proceedings for a declaration rather than waiting to be sued for infringement by the SEP holder, and those reasons were agreed with by Lord Justice Moylan. While I'm in this authority, I should show you paragraph 27 at page 1078, which deals with the jurisdiction in relation to declaratory relief. And the point is emphasised 4 lines up from the end of 27 that the discretion is an unfettered one, meaning that its exercise is not dependent upon the claimant satisfying any threshold criteria. The key consideration is whether the declaration would serve a useful purpose. That will be relevant when we come to ground 1. And the final point I seek to take from this, we can get at paragraph 80, page 1090. The implementer is entitled to a license from the first day it implements the standard, provided that it's willing to take a license on FRAND terms. This is the corollary of the point I made in Interdigital against Lenovo. Furthermore, the implementer is entitled to a license which is continuous and not subject to interruption. So those are 2 recent authorities of this court endorsing in principle the ability of an implementer to bring a declaratory claim to resolve FRAND licensing terms. In paragraph 21 of our main skeleton, which is in the core bundle at tab 5, page 36, we give a whole series of examples. Core bundle, tab 5, page 36, paragraph 21. Examples of cases in which such claims were brought, or in which the Patents Court has said that in principle such claims are available. Whether, as one sees in 21.1, on the basis of a declaratory action, or 21.2, in conjunction with a claim for revocation or declarations of non-essentiality. And I don't think there is any issue taken with the correctness of this paragraph, but in any event, the avenue has been approved twice recently by this court. That then brings me, fifthly, in terms of my points on the law, the last point on the law, to the point about freestanding FRAND claims. And we say that Vestel is concerned with a case where there was no underlying pleaded legal right at all. That authority is in the authorities bundle at tab 52. This was a claim by a Turkish television maker for FRAND declarations relating to a pool and specifically to a pool license offer made by many different SEP owners. The claim was made against the pool operator Access Advance and against one of the SEP owners, Phillips, sued as a representative of the other members of the pool. Lord Justice Burse, at page 1600 of the hard copy, paragraph 1, I should point out, Lord Justice Burse was agreed with by Lady Justice Elizabeth Lang and Lord Justice Nugent. At paragraph 1, Lord Justice Burse emphasised in the last sentence of that paragraph that owing to various shifts in the way the claimants have put their case, it will be necessary to go through some of the procedural steps in detail. So this is a case where one needs to understand precisely what happened in order to see what it decides and does not decide. There's reference to the parties, Phillips and Access Advance in paragraphs 4 and 5. We can see from paragraph 7 that the PPL, that's the pool license offer, was a worldwide license. It licenses patents from the whole world, including UK patents. And paragraph 8, that the action began as a competition law claim by Vestel for abuse of dominance under Article 102 of the FEU Treaty and the Competition Act 1998, brought against Access Advance and Phillips, and then there's reference to the representative capacity issue, which wasn't before the Court of Appeal. From paragraph 9, that we can see that the particulars of claim pleaded Vestel's case on the relevant market, the alleged dominant position, and the alleged abuses. Paragraph 10, the relief Vestel sought was for the court to grant declarations. And we can see one of those declarations was that the PPL was not FRAND, whereas Vestel's counter offer was. Paragraph 11 refers to Unwired Planet and says that by that judgment the existence of a jurisdiction to make FRAND declarations has been confirmed. It says, however, this case is in a different form from the previous ones. Cases like Unwired Planet are essentially claims for UK patent infringement. And we can see that the declaration in that case is granted as part of the relief. However, in the relevant regime, this is 4 lines up from the end of 11, the infringing implementer has a right legally enforceable against the patent holder to insist on being granted a license on FRAND terms instead of being injuncted. If, as commonly happens, the parties cannot agree what terms are FRAND, the court uses its declaratory powers to sort that out. This case is different because it's an implementer which is seeking a FRAND declaration. There is no claim for patent infringement, nor have Vestel used the machinery available to them under the Patents Act 1977 to bring a claim for a declaration of non-infringement or revocation of any SEPs before the court. So that is one distinction, because in that case there was no claim for revocation, which Lord Justice Burse identifies as one of the vehicles. Paragraph 13, when the action began, Vestel's case was legally coherent in that the claimants were bringing it as a claim in tort against the defendants for abuse of dominance and then seeking the FRAND declarations as part of the remedy. Now, the judge's judgment ruling in favour of Phillips and Access Advance is summarised at paragraph 17 onwards. We can see paragraph 20, the problem with Gateway 11 was different. The respondents argued that since the licence which Vestel contended was FRAND was a licence of SEPs in every jurisdiction all over the world, and since the UK SEPs within it represented less than 5% of the patents, the claim did not relate wholly or principally, my emphasis, to property within the jurisdiction, and so the gateway was not satisfied. And we can see that in 21, shortly before the hearing below, Vestel had sought to amend its particulars of claim to add a new alternative plea for 2 declarations drafted so as to emphasise that the licence on offer and the terms sought to be settled as FRAND by the court were the terms of a licence to the UK patents, and the judge had held that it didn't make any difference. And we can see that Vestel then sought to appeal, And critically, at paragraph 28, and this is really what the case turned on, in early 2021, Vestel made a radical change to its case on this appeal. The claim based on abuse of dominance was dropped altogether. Draft amended versions of the claim form, particulars of claim and grounds of appeal were produced, save in one minor respect. The draft amendments consist entirely of deletions. And one can see from that paragraph, competition law was removed altogether. There were just claims for declarations about FRAND. And critically, as the court emphasised a number of times in the subsequent reasons, there was no pleading of any legal obligation, any contractual obligation to grant or offer a FRAND licence at all. And we can see in paragraph 30 that Lord Justice Burse allowed the amendments. And in paragraph 34 over the page, came to the point I was just making to the court. Before leaving the procedural issues, I will make one final observation. Notable by its absence is a claim by Vestel that it has a legally enforceable right to a FRAND licence. I shan't read that whole paragraph, but perhaps I can ask the court to read it. So competition law had been dropped and no contractual right, entitlement or standard pleaded in its place. Now, although it doesn't arise directly in our case, some of the court's reasoning on appeal ground 3, which is claim in tort, is relevant. What Vestel said was that they could get through gateway 9 in relation to access advance because their FRAND declarations were in effect claims for declarations of non-infringement of the UK patents. This was before the introduction of gateway 16A, which allows for specifically for declarations of non-infringement. And one sees in 43, based on Foley and Fisher, Vestel contends that a claim for a declaration of non-liability for the tort of infringing any of Phillips's UK sets would fall within Article 7.2. I agree. However, the question then becomes whether that's the right way to characterise the claims for FRAND declarations in this case. I believe it is not, for the following reasons. Now, paragraphs 44 to 48 summarise On My Planet in the Supreme Court and emphasise the point that the Supreme Court had dealt with the issue as one of contractual entitlement. And 48 observes, finally, in relation to the Supreme Court's judgment, the specific contract which gave rise to the particular FRAND obligation in issue itself played an important role in the decision. And he then refers to what the Supreme Court had decided on non-discrimination, which turned in part on the travaux préparatoires of the ETSI IPR policy. At paragraph 49, Lord Justice Burse summarises the declarations now actually sought by Vestel after dropping the abuse of dominance plea. And they're in this form, and then he lists it out. A declaration that the terms of the draft PPL, insofar as they relate to any patents in the pool which designate the United Kingdom, are not FRAND. That the terms of the claimant's counteroffer are FRAND. Alternatively, a declaration as to what would be FRAND for the patents within the UK, the patents within the pool which designate the United Kingdom. Alternatively, those owned by the second defendant. Now, those are, as my learned friend Mr Nicholson points out in a table in his skeleton argument, materially the same as a number of the FRAND declarations that we seek in this case. 51. These declarations do not provide that Vestel has a right to any such licence. That might not matter if the particulars of claim did plead a case that Vestel has a legal right to such a licence, but they do not. In argument, counsel for Vestel suggested such a right arose because for Phillips to refuse would be an abuse of dominant position, but the judge points out that's been dropped. 52. Counsel for Vestel also referred in a general way to the ITU rules which require Phillips to undertake to offer FRAND licenses on SEPs declared to the standard. However, no case that there is any such right enforceable by Vestel is pleaded in the particulars of claim either. The omission, etc., the judge speculates whether it might have been because of jurisdictional difficulties, etc. But this is the critical point. There's no pleading of the contractual entitlement at all. And 53 emphasises that in the absence of such a claim, this clearly wasn't a claim for a declaration of non-liability in tort. And this claim, we do plead, as I'll be showing you, that Tesla is a beneficiary. We do plead the contract. We do plead that we have a right to a licence. I turn then to Gateway 11, which is at paragraph 61 onwards. And Lord Justice Burst rehearses the point that had troubled the judge about UK patents only making up a small share of the property concerned. We see from paragraph 66 that on appeal and as a result of the various amendments, Vestel now put the case they wish to advance in the following way. And we see that reliance was placed on useful purpose and Rolls-Royce. And one sees from the end of that paragraph, therefore, the subject matter of the claim relates wholly or principally to property within the jurisdiction, so the case falls within Gateway 11. The fact that the licenses of the UK patents, which would be FRAND, would also license patents from other countries cannot alter the fact that what Vestel is entitled to and is seeking is a licence under the UK patents. At 68, we see the judge emphasised that the debate was therefore not just about Gateway 11, but also reasonable prospect of success. And at paragraph 69, as has already been said, Vestel have identified no legal right to the declaration sought. The most they have is a legal proceeding which asks the court to exercise its inherent jurisdiction to grant these declarations. Then in 70, the judge interprets the reference to claim in Gateway 11 as a reference to a legal claim. In other words, it refers to a claim concerning a legal right of some kind and in some way. It may be a claim for which the only remedy sought is declaratory. And we can see at the end of that paragraph, however, there must be a legal claim of some kind. And then 71, I am prepared to accept that if Vestel did claim to have a legally enforceable right against a patentee or a licensing agent of a patentee, whereby Vestel were entitled to be offered a FRAND licence under the UK SEPs and the HEVC advanced pool, then the subject matter of that particular claim would be the UK SEPs. The question that claim would be concerned with is the licence terms which are available to license those UK rights. The fact that the only licence of the UK patents, which is FRAND, would also involve licensing foreign patents does not alter the subject matter of the claim. The fact that UK patents in the FRAND licence were only 5% of the patents licensed by it would make no difference. I would hold that such a claim was one which related wholly or principally to property within the jurisdiction and therefore fell within Gateway 11. And we see where the problem then came again in paragraph 72. However, Vestel's claim here is for the court to exercise the inherent jurisdiction to make a FRAND declaration despite the absence of an assertion of a right to such a licence. There is then on the facing page discussion of a case called Pfizer, which I don't need to go through. I can pick it up in paragraph 77 in the fourth line from the end. The judge says, therefore, Pfizer, which is the high point of Vestel's argument on this topic, is not an example of the court holding that the declaratory jurisdiction can be engaged on the sole basis that it would serve a useful purpose, and in the absence of any putative legal claim at all, or any legal standard against which to judge the matter. And then at 78, the judge reiterates his point that one needs a legal standard against which to judge the claim declarations. And in the last sentence reiterates, although Vestel refer to the ITU rules, it does not contend in these proceedings that they have legal force. It is hard to know how to decide whether the declarations sought untethered to any legal standard actually could serve a useful purpose, but that is not the basis on which I reject this part of the claim. I will take it that there is some arguable useful purpose, even if that is so. The attempt to invoke the court's declaratory jurisdiction has no reasonable prospect of success because it is not based on the existence or non-existence of a legal right. So that's my fifth point on the law. We say when Vestel speaks about there being no such thing as a freestanding declaratory claim, what it is concerned with is a situation where there was no pleaded contractual entitlement, standard, or right whatsoever.
It's hard to believe that the court here is deciding this on the pure point that Vestel didn't plead the contractual entitlement.
Well, in my submission, my lord, it very clearly is.
That would be a very strange basis for the court to decide it.
Well, no, my lord.
The court's well aware of UP in the Supreme Court and what it's decided. It would be bizarre to say that the court just decided this on the basis that that contractual claim wasn't pleaded.
Can I give my lord? I think there are two answers to my lord's question. The first is, I hope I've shown my lord by reference to the reasons given by Lord Justice Burst that was indeed in my submission, my respectful submission, the precise basis on which Lord Justice Burst was dealing with the case. Indeed, there are paragraphs, I think paragraph 58 from recollection actually specifically makes the point that counsel for Vestel had referred in the abstract to the ITU rules, but there was no pleaded claim about them. And that's a point that the judge came back to on a number of occasions. So I think the first answer is, we would submit respectfully that is the basis on which Vestel was decided. But the second answer to my lord's question is that the point that the judge makes about unwired, let me find the paragraph, explains why the particular contract matters. This is the judge's point about non-discrimination in Unwired Planet having turned on the specific contract which gave rise to the particular FRAND obligation. That's paragraph 48 of his judgment. And this was a case, this was not an Etsy FRAND case. This was an ITU case. And in fact, the court didn't need to go into any of this because there was no pleaded claim. But the ITU policy has no governing law clause at all, for instance. So there's a question as to what the governing law of any stipulation pour autrui or equivalent in relation to the ITU policy even would be. Now, of course, none of those questions arose because there was simply no attempt to plead any kind of contractual case at all. And Lord Justice Burst makes quite clear in his reasoning, particularly on Gateway 11, that had there been such a pleading, then the claim would indeed have passed through Gateway 11. And my lord, that is not an analysis in which I am alone. That is an analysis which has been accepted in at least two recent decisions of the Patent Court in jurisdiction on FRAND cases. And if we go first of all to Authorities 2, tab 22. At this point, I should say, I know it's 11:45. I don't know whether we were planning any transcriber breaks. I'm most grateful. Authorities to tab 22. This is a decision of Mr Justice Richards in Lenovo and Ericsson. This is the decision we saw referred to in paragraph 14 of Panasonic and Xiaomi. And in tab 22, at page 659 of the hard copy bundle, there's reference to entitlement to a FRAND license. And in 5, the judge says the potential for a court determination of such a license arises in 2 distinct ways. That's in that set of proceedings. So number 1 is that Lenovo had sought conventional injunctive relief on a set. And subparagraph 2 is in the same proceedings, Lenovo has challenged the validity and essentiality of 2 of Ericsson's UK patents, described as the challenged patents in the jurisdiction judgment. It has also asserted that Ericsson has breached its FRAND commitment to offer licenses covering the challenged patents on FRAND terms and sought declarations accordingly. And 6 emphasises that FRAND has been put in issue in 2 different ways as a result. We see at 15 the same point about the possibility of a determination arising in 2 different ways, not just in an infringement claim. And then in the context of considering the claim to FRAND declarations, at paragraph 22, next, Ericsson categorises the claim for a declaration of the terms of a FRAND global cross-license that did not rely on a prior finding of infringement of the Lenovo patent as a freestanding claim of the kind proscribed in Vestel. I do not accept that categorisation. Counsel's close examination of Vestel demonstrates that the reason the claim for a determination of FRAND terms in that case was freestanding was because it was not linked to any asserted legally enforceable right to a FRAND license. By contrast, in the present proceedings, Lenovo does assert a legally enforceable right arising out of Ericsson's FRAND commitment based on the challenged patents. That legally enforceable right is said to consist of a stipulation de contrat pour autrui that takes effect as a contractual promise under French law, which Lenovo is entitled to enforce. And then there is reference in paragraph 23 to precedent for an implementer bringing a claim of that nature.
What's the stipulation de contrat pour autrui? Does that mean a sort of open offer to contract with whoever comes?
It's a contract for the benefit of third parties.
Yeah.
So what happens with the Etsy scheme is that the SEP owner makes a promise to Etsy. So the contract is between the SEP owner and Etsy. But that is a contract which not only exists for the benefit of third parties, but is actually specifically for that purpose, because it's a promise to grant a right to a third party. So, and I won't attempt a homespun translation as I stand here, but the word autrui, I think, reflects the fact that it's a promise for others.
But it would lead to a contract, a separate contract with that third party, would it? Or can the third party just rely on it because it's there without anything happening? Maybe it doesn't matter. I
think for present purposes it doesn't matter because as a beneficiary of a third party stipulation under French law, you are yourself entitled to enforce the obligation owed, even if only owed to Etsy. And my learned friend asked me to...
Is that what was missing in the other case then? So that's the difference with Vestel, is it? That there wasn't that French contract promise thing that could be sued on.
Exactly, my lady. I mean, and what happens is, well, and as I say, it may not have been French law in that case at all, because it's the ITU policy, and in fact, without a governing law clause, what the governing law of that contract actually is open for argument, and in other cases it's been said to be Swiss law. In the Alcatel and Amazon case, which was in fact the second case I was going to come to on this question of Vestel. My learned friend, however, first of all asked me to read the first sentence of paragraph 25, which is, overall, I conclude that the court has power to make a declaration as to FRAND terms without first finding that the Lenovo patent is valid and infringed.
Yeah, but that's why what the judge said mattered, because that was the whole basis of Ericsson's argument that he couldn't do what Lenovo was asking him to do. And permission to appeal at that point was refused.
Indeed, my lord. The same analysis of Vestel was arrived at also by Mr Justice Zaccaroli, as he then was, in Authorities 1 at tab 3, Alcatel and Amazon. This was a claim by
I've lost the tab again.
I'm so sorry, it's tab 3 in Authorities 1.
Thank you.
Now, this was a claim by Alcatel against Amazon under UK patents which were not said to be SEPs, but Amazon was permitted to counterclaim for a RAND license because it said, based on Nokia's prior licensing practice, that such a license would cover the patents in suit. And Mr Justice Zaccaroli, in this context, amongst many issues, had to consider the issue about Vestel. And if one goes to page 74 in the hard copy, paragraph 106, and we can see from paragraph 106 that reliance was placed on Vestel. We can see in the last 3 lines that Vestel had originally anchored these declarations to a claim of abuse of dominant position, but by the time the case reached the Court of Appeal, that claim had been dropped. And then we can see the first 5 lines of the next paragraph, I don't think I need to read there why the issue arose under 16A, sorry, under 9 rather than 16A. That was because, 5th line, having abandoned its claim for abuse of dominance, there was no pleaded case that Vestel had a right to be granted a license on FRAND terms. Vestel did not, for example, plead any enforceable contractual right based on the ITU rules. Without a pleading of an enforceable right to a FRAND license, Vestel's claim could not be characterised as a claim for a declaration of non-infringement of the patents in issue. And we see from paragraph 110 that Mr Justice Zaccaroli, as he then was, agrees with those comments of Lord Justice Burse. Now, while I am in this authority, I should also point out that at paragraphs 116 to 120, the learned judge rejected, for reasons that he explains and which I shall not read out at length, he rejects a challenge to the correctness of paragraph 71 of Vestel in relation to Gateway 11. And the net effect is in 120. In my judgment, this obiter comment of Lord Justice Burse is correct. Nokia's argument confuses the subject matter of the license that is sought with the subject matter of the claim that is brought. The claim is one to enforce the contractual obligation of Nokia, etc. That is a claim which relates wholly to property within the jurisdiction, even though the license sought is one that covers a global portfolio of patents, of which the UK patents are only a small element. The legislative history of the rule does not, in my view, affect that conclusion. I draw attention to the legislative history there because the very same report that was relied upon by Nokia, as one sees from paragraph 117, has been put in the bundle by Mr Raphael. If an argument is developed in relation to it, we rely on Mr Justice Fancourt's rejection of that argument. So, my lords, my lady, I do submit respectfully that it is the basis on which Vestel was decided, that there was no pleaded claim in relation to any contractual obligation to grant, or specifically to offer, a FRAND licence. So that was the first of my 7 main topics. The second is serious issue to be tried against Appellants. And we submit quite simply that this is not a claim like Vestel was. To the contrary, we have supplied what was missing in that case by pleading Tesla's contractual entitlement to a licence under the 3 challenge patents, under all of Interdigital's UK patents, and indeed under all of the UK SEPs in the pool. And the claim to FRAND declarations in relation to those patents is perfectly viable against Avanci, given that it is the appointed and authorised licensing agent which has made the offer in question on what it says are FRAND terms. That is a claim which relates to a pleaded legal obligation and clearly serves a useful purpose. And the position is then a fortiori, given the claim against Interdigital also, based on the challenge patents and based on its obligations in relation to its UK SEPs. Now, before I turn to the pleading, I should emphasise that, of course, the issue at this stage, for the purposes of jurisdiction, is only whether there is a serious issue to be tried. The court is not deciding whether to grant declaratory relief at this point. The court is only deciding whether there is a real prospect that a trial judge would grant FRAND declarations against Avanci. Now, we set out the very familiar law on serious issue to be tried at paragraph 47 of our main skeleton. And in essence, as Lord Justice Coulson said in the Begum and Moran case, the court is considering whether the claim to declarations is bound to fail. As we explain in paragraph 47 of our skeleton, in the Tulip trading case, the court also clarified that the traditional reticence about striking out in developing areas of the law applies equally in the context of disputes about serious issue to be tried for jurisdictional purposes. Again, I don't think that's in dispute, but that's in Authorities 2, tab 47. Now, this is, of course, a very rapidly developing area of the law, as the judge's reasons for granting permission to appeal recognise. Now, another synonymous test is whether a given contention is hopeless, and we can see that applied in the context of a declaratory claim in the Ultimo case, which is in Authorities 1 at tab 4. This was a claim, the Authorities 1 tab 4, page 86. This was a claim in which a Kyrgyz company sought to enforce a Kyrgyz judgment against Isle of Man companies. Isle of Man companies had counterclaimed, contending, amongst other things, that the judgment in Kyrgyzstan had been obtained by fraud, and there was a jurisdiction challenge in relation to counterclaims. If I go, please, to page 112 of the bundle, at paragraph 103, in the judgment of the Privy Council, we see in the fourth line, bound to fail and no serious issue to be tried tests are different ways of putting the same point, which is that the claims against the Appellants and Vestel in relation to the 2005 and 6 judgments are hopeless, and in this section the tests will be used interchangeably. And that, of course, is a particularly difficult conclusion to reach in relation to a declaratory claim where the relief is discretionary and depends on the circumstances at the date of trial, which is a point that the Privy Council make at paragraph 126. Now we can see from 125 that one of the things that was said was, well, there's no serious issue to be tried on the declaratory claim because it couldn't ever serve a useful purpose, etc. And at paragraph 126, the Privy Council's answer was pretty short. The answer to this point is that declaratory relief is discretionary and depends on the circumstances at the date of trial, and there is no material which would indicate there is no prospect of obtaining it. And we say, approaching the matter correctly, the judge did err in finding that there was no real prospect of FRAND declarations against advancing. We can find the, well, let me show you the pleaded case first of all. This is in the core bundle at tab 50. The particulars of claim. And if we can go first of all, please, to page 168. In the introduction to the parties, we see at paragraph 14 that there is a pleading as to Interdigital's UK SEP portfolio, that includes the challenged patents as defined below. Those are the 3 patents put in issue on the revocation and declaration of inessentiality claim. At 15, we plead that that portfolio is part of a wider international portfolio. At 18, we plead the existence of the Avanci pool, both 4G and 5G. 5G is the relevant one for our purposes. At paragraph 20, on page 170, we plead that when patents are brought to the attention of ETSI, etc., the declaration is given, and we see in last sentence, these licensing declarations give rise to certain contractual obligations for those declarants under French law. The FRAND commitment discussed further in section E below. At 21 onwards, we explain how the agency arrangement with Avanci works. At 24 and 25, we explain that the members are in fact disincentivized to enter into bilateral licenses. At 26, we plead the representative claim against the third defendant. We seek the FRAND declarations against the third defendant as a representative of all Avanci 5G pool members, alternatively all such members who do not already have a bilateral license with the first claimant. And the judge explains there's only one such person. We can then go forward to paragraph 39, please. Having set out the challenge patents and the reasons why they're said to be inessential, we have 39 that they are part of the UK SEP portfolio and the international SEP portfolio and part of the pool. At 40, we have Tesla is a beneficiary of Interdigital's FRAND commitment. It is accordingly entitled to a license on FRAND terms covering Interdigital's international SEP portfolio, including the UK portfolio and the challenge patents, and further entitled to such a license by the time that it begins to sell. 41, as pleaded below, Tesla is a beneficiary of the FRAND commitments of all of the Avanci 5G pool members. It is accordingly entitled to a licence on the FRAND terms covering the 5G pool, including the set portfolio, the UK set portfolio and the challenge patents. At 42, we plead that a FRAND licence covering the challenge patents is a licence under the whole pool. Last part of 42 before the subparagraphs, for present purposes in the specific context and circumstances of this case, it is averred that a FRAND licence covering the challenge patents has at least the following terms. And then we explain that it covers the pool. At 44, there is an undertaking to take a licence covering the entirety of the pool on whatever terms are determined to be FRAND. Now, I made clear below, and I make clear again here, that if anything turns on it, Tesla is prepared to undertake to take a licence under Interdigital's UK SEPs on whatever terms are determined to be FRAND. The relevant passage of transcript below is in tab 29 of the supplemental bundle. We don't need to go there, but it's there for you. I know friend is saying what I've just said is different from what I said at tab 29, but we are prepared, if anything turns on it, to undertake to take a licence under Interdigital's UK SEPs, or indeed the challenge patents themselves, on whatever terms are determined to be FRAND. Going back to the pleading, we have at page 179, paragraph 46, all patents in the pool, including the challenge patents, are encumbered by FRAND declarations and therefore FRAND obligations. At 47, we plead that the challenge patents are the subject of licensing declarations. At 48, we plead that all the other members will have made equivalent licensing declarations. At 49 to 52, we plead the ETSI IPR policy. At 53, we plead why the construction, validity and performance of the policy is governed by French law and continues to be post-Brexit. At 54, we plead that by signing the Interdigital licensing declarations and the Avanci pool declarations and returning them, Interdigital and each other Avanci 5G pool member, as applicable, entered into a contract with ETSI, whereby each pool member is bound to grant licenses of its essential IPR, including the challenge patents, on terms and conditions in accordance with clause 6.1. 55. So just pausing there, we do say that is a clear pleading of a contractual entitlement of the kind that was simply not there in Vestel.
But not as against Avanci.
No, that's right, my lord, and I was about to come to that, because there is a passage. I should just finish off by saying 55 pleads the point that it's enforceable by any member. Sorry, against any member by Tesla.
Do you plead any legal right against Avanci?
We do not assert that Avanci itself owes a FRAND obligation. There is a passage of the pleading, and I'll show my lord the draft amendment, because I think it's important that I clarify that. But and I hope I was clear also in the skeleton and below. We don't say to the judge.
Why doesn't that bring you directly into the Vestel problem then? You haven't pleaded a legal right as against the defendant.
Because Vestel decides only that in the absence of any pleaded legal standard at all, a claim is freestanding. It is not the law that a claimant needs to establish a legal right owed by the defendant or every defendant to a declaratory relief claim in order to be able to seek declaratory relief in relation to that legal obligation. That's the point decided in Rolls-Royce and in Milebush, which we cite in the skeleton argument. And it would be contrary to those authorities to read Vestel as deciding that you have to enjoy the legal right against every defendant to your declaratory claim, or indeed any defendant to your declaratory claim. If there is a legal standard, and if the grant of declaratory relief serves a useful purpose, then the court has jurisdiction to grant declaratory relief. Here, there can be no question as to useful purpose because Interdigital's own position is that a declaration by the court will be respected. But in any event, we are in a situation in which Avanci is intimately interlinked in the discharge of the contractual obligations owed by the SEP owners. This is why I took the trouble earlier to go through the extent to which not only has this offer been represented to the market as a FRAND offer, but is in fact relied on in infringement proceedings by SEP owners as a FRAND offer. Avanci, as agent on behalf of the SEP owners, is purporting to discharge their legal obligations. And we say that comes well within the jurisdiction in relation to declaratory relief. There is a legal standard, there is a useful purpose. But my lord is right that we do not assert a legal right against Avanci itself. We don't say Avanci owes an Etsy obligation. It is simply...
So you say that, and which gateway does it go through?
The claim against Avanci gets through, well, there are a number of different permutations, my lord. If one were considering it purely on its own, gateway 11. However, the judge also found that if the FRAND declaration's claim against Interdigital was arguable, and we say it clearly was, then that was a claim which was served within the jurisdiction under 63.14. So it's a service in case. And then Avanci is a necessary or proper party to that.
But we're just considering Avanci now, aren't we?
Well, one of the points we make is that when one's looking at serious issue to be tried, there's no requirement, in fact, to consider the position of Avanci in isolation. The authority that my learned friend relies on, the Red October case, is a case specifically about the wording of Gateway 3. It is not a case about assessing serious issue to be tried generally.
Shall we finish going through the pleading?
Yes, my lord. At paragraph 57. Now this is the paragraph which is amended. So at this point I should switch into the draft amended version at 57. Sorry, at tab 16, page 203. We'll see at 57, we sought to plead. I'm not any longer pursuing the application for this particular pleading, but to explain how the issue has developed. We sought to plead that Avanci would be liable for failure to effect good faith performance of the licensing declaration as a joint party. The judge said there wasn't such a damages claim there, so it didn't matter. So we're not pursuing that point, but it does show how intimately involved in the discharge of the legal obligations Avanci in fact is. But then the critical amendment, which you see at 59, is we have removed the allegation that Avanci itself owes a contractual obligation. And I make clear we're not saying in this court that it does, and didn't below. We then go back to the declarations, which are on page 183. Declarations 1 to 3 are the patent declarations. Declaration 4 is a declaration that Tesla is a beneficiary of the FRAND commitments of Interdigital and the 5G pool members. So that's a pleading of the entitlement to enforce the commitment. Declaration 5 is a declaration that the terms of the SPLA, insofar as they relate to any patents in the Avanci 5G pool which designate the United Kingdom, are not FRAND, and therefore do not comply with the relevant FRAND commitments. Alternatively, a declaration as to the terms which are FRAND for those patents, alternatively such patents within that pool as are owned by Interdigital. 6, a declaration that the FRAND licence covering the challenged patents, well, the court can see, is the pool licence. 7 and 8, I make clear we are not pursuing. And 9 and 10 are declarations that the terms proposed by Avanci for a licence covering the pool, including the challenged patents, are not FRAND. And 10 is a determination of what terms, including the challenged patents, would be FRAND. So this is, we say, a claim for declarations related to pleaded legal rights to be offered a FRAND licence under UK property rights, which are being administered by Avanci as agent on behalf of their owners. And I submit that Avanci does not itself need to own the property rights or to owe the relevant contractual obligations for the declaratory relief to be viable and to serve a useful purpose. Now, the judge's reasons for the contrary conclusion can be found at judgment at paragraph 74 to 80. That's in the core bundle, tab 10, at page 129 onwards. And the critical reasoning is at paragraph 78 and 79. Specifically, the last two sentences of paragraph 79. But I would ask the court to read 78 and 79 again. My lords, my lady, the critical sentences say the claim would be, these last two sentences of 79, the claim would be a freestanding FRAND claim as in Vestel. If Tesla were right about its claim against Avanci, the claim against Access Advance would have been permitted to proceed in Vestel on the basis that Phillips and the other patentees in the pool had given FRAND undertakings to ITU. Now,
To which you say that simply wasn't pleaded.
that simply misreads Vestel, my submission,
Yeah.
very clearly.
And
that's
you
not-
say there's an inconsistency with what the judge says at paragraph 84.
With 80, sorry, my lord.
What the judge says at 84, you say is inconsistent?
Well, it is indeed. One of the oddities of this judgment, as we point out in the skeleton argument, is that the judge, having come to this conclusion in two very short sentences in paragraph 79, and disposed, so he thought, of the arguability of the claim against Avanci, then in the context of the claim against Interdigital, proceeded to cite the law which showed why that was wrong. I.e., the whole discussion which takes place from 84 onwards, for instance 89, which cites Rolls-Royce and says the court's jurisdiction doesn't depend on there being a cause of action against a defendant. Feetham and directly affected Milebush in 92. Now, that being so, that actually shows why paragraph 79 is wrong. So the first point is that is simply a misreading of Vestel. I've been over that. You have my submissions. You have the conclusions reached by Mr Justice Richards and by Mr Justice Zaccaroli, as he then was, which are entirely consistent with the submission I'm making. I say that's very clear. Indeed, the judge's point in the last sentence of 79 is actually addressed by Lord Justice Burse in Vestel itself. The judge says in the last sentence of 79, if Tesla were right about its claim against Avanti, the claim against Access Advance would have been permitted to proceed in Vestel because of the ITU undertakings. As I showed you in Vestel, the judge actually deals with that point. Lord Justice Burse at paragraph 58 says, yes, Vestel mentioned the ITU undertakings, but they didn't plead them. Sorry, it wasn't 58, it was 52 in Vestel. Now that's the first point. We say it's a misreading of Vestel. But secondly, the judge's interpretation of Vestel would be contrary to the general law on declaratory relief, which does not require the existence of a cause of action against the defendant to the claim for declarations. And the judge has in fact identified much of the relevant authority in his section on interdigital. But let me just show you very briefly some cases on it. First of all, Rolls-Royce, which is very well known. That's in Authorities 2 at tab 39. And the very well-known summary of principles by Lord Justice Aikins, subsequently approved by this court, albeit in this case it was in fact obiter, is at page 1227 of the hard copy bundle, paragraph 118. And we can see the court's present jurisdiction to grant a declaration derived from statutes, reference to CPR 4020. It's well established that a claimant does not need to have a subsisting cause of action against a defendant before the court will grant a claimant a declaration. The grant of a declaration is discretionary. The law has developed since the statement of principle by Lord Diplock in Gourier. Next to C on the opposite page, there is no doubt that the circumstances in which the court will be prepared to grant declaratory relief are now considerably wider than they were thought to be after Gourier and Meadows. In the words of Lord Justice Jonathan Parker and Feetham and Levy, things have indeed moved on, and the court should not nowadays apply such a restrictive meaning. And 120 is the principles, the first of which is that it's discretionary. Second is...
Sorry, just before you go on, I mean, I'm not sure there's anything you can really say about this, but one of the oddities about this case is that there's no reference to the foundation of the modern law on the subject, which is Lord Wolfe's judgment in Messier Doughty. Apparently, what the explanation for that is it wasn't cited, because if you look at the list of cases cited, Messier Doughty is not there. It seems quite odd, given it's such a well-known judgment, and as I say, is generally recognised as being the foundation of the modern law. I'm not suggesting it's in any way inconsistent with what Lord Justice Aikins says. On the contrary, it might be thought to provide further and better support for it.
If anything, it goes further, and I may be misremembering this, but in the passage from Panasonic and Xiaomi, which I showed the court earlier on declaratory relief, I think paragraph 27, I can check that. I think there is reference to Messier Doughty in that paragraph.
There is.
Anyway, as I say, that's just how it is.
And my lord, obviously, points 2 and 3 are of obvious relevance. There must in general be a real and present dispute between the parties before the court as to the existence or extent of a legal right between them. However, the claimant does not need to have a present cause of action against the defendant. Now, that is exactly our situation. Avanti has been appointed as agent to discharge a legal obligation on behalf of the SEP owners. It's accepted as arguable that in making the offer, it is indeed purporting to discharge the obligations of the SEP owners. We say the offer is not FRAND. Avanti says it is. That is a dispute as to the existence, or in this case, the extent of a legal right.
That's not what this is. Forgive me, that's misreading what this is all about, there, isn't it? This is talking about where there are legal relations between parties, or potentially so, but have not yet given rise to a cause of action. It's not saying that you don't have to have. It's saying there must, in general, be a real and present dispute between the parties as to the existence of a legal right between them. And that's why, and then the claimant does not need to have a present cause of action against the defendant. But what's anticipated is that there will be a cause of action against the defendant. Well, but there will never be a cause of action against Avanci.
Well, I would submit, my lord, that the ultimate touchstone that's laid down here, I mean, ultimately this is all a question of discretion, of course, guided, we're told, only by the requirements that it concerns a legal standard and serves a useful purpose. But insofar as this identifies anything additional, it is that it is principle 3, that each party must in general be affected by the court's determination of the issues concerning the legal rights in question.
Well, that seems to me to be an open question as regards Avanci, because their role is as agent.
But they are, my lord, unquestionably affected by the grant of declaratory relief. The reason being, and that's the reason why I took the trouble when going through the facts, to emphasise that the rate is Avanci's rate. The evidence of Interdigital in particular is they were presented with that rate as on a take it or leave it basis. They say they don't know how even to justify it as FRAND. That's all in the knowledge of Avanci. So Avanci has set up this scheme, has come up with a rate, has got people to sign up to it, has presented it to the market as FRAND. It is being relied on by SEP owners as FRAND in legal proceedings. If a court says that it is not FRAND, we are told by Interdigital, very fairly and realistically, that in practice it would be untenable for the members of Avanci to do anything other than require Avanci to think again about its rate. That is, in my submission, plainly a direct effect on Avanci. That's the Rolls-Royce case. The same point arises in...
What about factor 6 in the list?
Yes, my lord. Well, I'm obviously going to come to that in some detail in the context of the objections that the judge raised to proceeding against Interdigital.
And assume also item 7.
So I am most certainly going to come to that issue, about the fact that the other members will not be before the court unless by way of the representative. Milebush is the second case I wanted to take the court to. It is in Authorities 2 at tab 28. We have, first of all, I should show the court Lord Justice Mummery.
Another case in which Messier Doughty was not cited.
My lord, I hadn't noticed that.
Just extraordinary, really. But there we go.
At page 881 of the hard copy bundle, at paragraph 44.
Sorry, page number again?
I'm so sorry. Hard copy, page 881.
Yep.
The authorities show how, and this is in relation to declarations, how a declaration may be granted in private law proceedings about the disputed construction of a document affecting the claimant, even though the claimant was not a party to it. And then 46, the judge approves the principles in Rolls-Royce. And the issue in that case, the reason why declaratory relief was not appropriate in that case, as one sees from the further reasoning, was that it was an issue that was better decided in a judicial review claim, which is a point that Lord Justice Mummery makes at paragraph 48. Now, this was agreed with by Lord Justice Jackson at paragraph 95. Lord Justice Morbick, dissenting in relation to the outcome, but not in relation to the law, deals with the relevant principles in some detail from paragraph 65 onwards. There's no time to go through it all, but there's a discussion of Mercury communications in the House of Lords at paragraph 77. The learned judge in the seventh line says, in my view, the decision strongly supports the conclusion that the court can, and in some circumstances will, determine a dispute relating to the construction of an instrument if both parties to the proceedings have a sufficient interest in the outcome, even if one or other is not a party to it or does not acquire any rights under it. To similar effect, we see in 83 reference to FSA and Rourke, the power being unfettered to grant declaratory relief. At 84, there's discussion of Feetham and Levy. And at the end of that paragraph, about 7 lines up, we see Lord Justice Jonathan Parker rejected that argument, both because the claimants were directly affected by the existence of any duty to comply with the statutory provisions, and because it would not be right to refuse declaratory relief simply because the claimants were not parties to the contract whose meaning they were seeking to have clarified. Then there's reference to Rolls-Royce. And at paragraph 88, in my view, the authorities show that the jurisprudence has now developed to the point at which it is recognised that the court may in an appropriate case grant declaratory relief, even though the rights or obligations which are the subject of the declaration are not vested in either party to the proceedings. And then the judge explains the position. So we do say the judge's reasoning in the last 2 sentences of paragraph 79 was clearly wrong. The claim is not a freestanding claim as in Vestel. We've pleaded what was missing. And Avanci has no respondent's notice. It doesn't seek to justify the outcome on any basis other than that identified by the judge. And the judge's reasons are, we say, not sustainable. That brings me then to the third of my 7 topics, which is serious issue to be tried against Interdigital. Now, the patent claims were found to raise a serious issue to be tried and not to be abusive. And there is no cross-appeal or respondent notice on those claims. I must say that Interdigital submissions are still somewhat laced with implications to that effect. And so before I turn to the judge's reasoning, let me be clear on this issue. We say bringing a revocation claim in relation to a small number of UK SEPs alongside a declaration of FRAND licensing terms attaching to those SEPs should be no more open to objection or criticism than a SEP owner bringing a claim for infringement of the very same patent or patents with the same structure. We know from Unwired that bringing a UK patent infringement claim and then seeking FRAND declarations on the back of it is a perfectly legitimate and proper course of action. There is no reason why the same should not be true in reverse. Indeed, if anything, revocation actions stand in a special position because they are not subject to any requirement to show any kind of interest at all.
No, because it's no requirement of standing, and it's deliberately so because it's a class remedy.
And because there is a public interest in the revocation of invalid patents. That's the TNS and Nielsen decision, which is in Authorities 2 at tab 44. Now, it's true, as the judge referred to on a number of occasions in his judgment, that Tesla proposed that the FRAND issues be heard first. Now, that, again, can hardly be criticised in my submission, when that is what the Patents Court, as we saw earlier from the judgment in Panasonic and Xiaomi, has been consistently encouraging claimants in FRAND cases to do. So we do say we should clear away any residual suggestion that there is something improper or illegitimate about the patent claims. There is not, and the judge rightly found that there was not. So the question under this head is instead whether Tesla has a real prospect of obtaining FRAND declarations against Interdigital, which relate to the FRAND licensing terms for those very same patents. Now, we submit that Tesla does indeed have a real prospect of success and that the judge was wrong to conclude otherwise. This action has indeed precisely the same structure, i.e. a revocation claim and then a claim for FRAND declarations, which was employed in the Kaigen and Thales case and in Lenovo and Interdigital. Those are cases to which we refer at paragraph 21 of our main skeleton, which I showed you earlier. And indeed, of course, we saw Lord Justice Burst making reference to the possible vehicle of a revocation claim at paragraph 12 of Vestel, something that again hadn't been done in Vestel. Now, the judge's reasons for holding otherwise can be found at paragraphs 85 onwards, core bundle, tab 10, page 131 of the hard copy bundle, 133 of electronic. Now, the judge has already found in 84, as we saw a moment ago, that it cannot be said that the declarations being sought are devoid of an appropriate standard or the claim is freestanding, that there are pleaded legal obligations. Then the judge goes on to ask the next aspect is whether any of the declaratory relief sought against IDH serves a useful purpose. That's D3. This was really the focus of IDH's challenge in the hearing and is closely related to the third aspect. Will the court grant declarations about the Avanci license in the absence of other patentees and Avanci? So he's asking, in the absence of other patentees and Avanci here, we can see from 87 that the basic proposition that the license in relation to the UK SEPs might be global and might be under the pool was regarded as properly arguable. That's 87. At 94, having gone through the authorities on declaratory relief, the judge observes that Interdigital did submit in support of his argument that patent claims were not real, that if FRAND terms of the Avanci 5G platform license were determined by the court, it is likely that the patentees would approve the grant of a license by Avanci on those terms. So it recognises that there will probably be practical consequences to such a determination, even if others are not legally bound by it. The same point that the judge comes back to in paragraph 97, that Tesla has a legitimate interest and there's justification for seeking the declaratory relief that it seeks, and the such like. Which then means that the critical passage is really from 98 onwards, which says whether it is fair and just to grant the declarations as sought in the absence of the owners of the 5G SEPs and Avanci is quite another matter, however. The other patentees will not have had the opportunity to put their cases on whether a FRAND license, etc., would include a worldwide license or what rate is FRAND. And he says it's not easy to see how Interdigital could properly advance those cases, and so on. And further practical points are made in 99 and 100. But then in 101, the judge says, in my submission correctly, the exercise might be possible if Avanci were also a defendant. as it acts as the agent of the patentees in connection with the licensing of the 5G steps and will have many of the relevant documents, but Tesla has no claim of right against Avanci. Now, on the point about claim of right against Avanci, that is the subject of ground one, and I've made no submissions. But what paragraph 101 rightly recognises is that if Avanci is there, then there isn't any unfairness to Interdigital. As I've already submitted to you, Avanci is the appointed licensing agent, but more than that, it devised the scheme, it devised the rate, it presented it to the members on a take-it-or-leave-it basis. Insofar as anybody is able to explain why the rate which is offered by Avanci is FRAND, that person is Avanci. Avanci's evidence is that the rate was chosen after discussions with licensors and licensees. That's Regendre 1, paragraph 9. And as we observe in our skeleton at paragraph 66, there is no suggestion that Avanci had access to the comparable licenses of its members when setting the rate. No suggestion. But even if it had, it would be Avanci that would know which ones were considered relevant and which were not. So the first point we make is if the claim against Avanci proceeds, as we say it should, then these fairness concerns about Interdigital fall away. Avanci will not be left bearing, as it puts it in its respondent's notice, vast cost or anything of that nature. The justification will be for Avanci, which Interdigital itself emphasises has the relevant information. Now, the second point we make in this connection is even if the claim against Avanci were not proceeding, there is nothing unjust or unfair in requiring Interdigital to justify an offer under its SEPs made by an authorised agent and which the agent has repeatedly presented to the market on its behalf as being FRAND, even if, in practice, it requires the assistance of that agent in order to do so. And the judge's reasoning in this section fails to take account of the practical reality that Avanci would unquestionably assist Interdigital in its defence of the claim in any event. That is the point that we make in our main skeleton at paragraph 65 and in paragraph 5 of our supplemental skeleton. Interdigital has no bilateral licensing programme for SEPs. It's chosen instead to offer them via the platform. It's been presented as a FRAND offer, and if Interdigital requires the assistance of Avanci to defend it as a FRAND offer, there is nothing unfair or unjust in that outcome. Indeed, that's not just speculation, that is what Avanci has said it will do. Avanci says that if the claim against Interdigital proceeds, then it not only wishes to assist Interdigital in defending the claim, it wishes to be a party. Now, my lords, there was a decision handed down by the Supreme Court recently in a case called Nexus, which has, I should start by emphasising, extremely different facts and arises in a very different factual context indeed, but which makes some observations which touch on this question. It is in the Authorities Bundle, Volume 2, at tab 32. And I will, I think, be able to get through it before the 12:55, which I know is a hard deadline. This was a case, so this is tab 32 of Authorities 2. This was a case where a Transport Executive Board, Nexus, had brought a claim against a trade union for the rectification of a collective bargaining agreement, and it had not named any employee whose rights would actually be affected if rectification were granted. The collective agreement itself was legally unenforceable, and both the Court of Appeal and Supreme Court held that Nexus had therefore sued the wrong person and should instead have sued an employee whose contract was actually affected. We can see in the judgment of the Supreme Court at page 996, paragraphs 1 and 2, paragraph 1 makes the point that these agreements are not legally enforceable contracts, but that are typically incorporated into employment contracts. And paragraph 2 summarises the various issues that arose. And there had been previous proceedings about the interpretation of this collective agreement, as one can see from paragraph 14. That Nexus had brought proceedings against an employee to have it interpreted in the way that it wanted, but they failed. And it therefore changed course and decided to sue the union that had concluded the legally unenforceable collective agreement for rectification of the legally unenforceable collective agreement. One of the important points about the context is that unions do not act as an agent for employees. That's made clear at paragraph 40 to 41. So a union is not out there as Avanti is negotiating legally on behalf of employees. It's concluding legally unenforceable collective agreements that employees then choose whether to incorporate into their contracts or not. And the court then deals with the question of who the proper defendants are from page 1009 of the hard copy bundle onwards, paragraph 53. Counsel for the unions founded their case on this issue on what were said to be two well-established principles of law. The first is that, as stated in Chitty, rectification will be ordered only so long as there is an issue about the parties, between the parties as to their legal rights inter se, and the court adopts those principles. So those are not the same principles as those in relation to declaratory relief. And at 55 onward, the court explains why proceeding against the union alone, in the absence of even a single employee, was regarded as unfair. And I shan't take the court through all of the reasoning, but essentially the court emphasises that you should be naming at least one employee as a party affected. And the objection to the union was, well, we'd have to sue our entire workforce at paragraph 57. And at 58, the court rejects that. The fact that one or more persons can give relevant evidence makes them suitable as witnesses, but has no bearing on whether they're proper defendants to the claim. In any case, we find it hard to think that if a claim for rectification were brought against the affected employees, the unions would decline to assist the employees by providing relevant documentation and witness evidence. In practice, they are likely to have the conduct of the employees' defendants. Courts, in any event, have ample powers to order non-parties to disclose or produce documents. As for the allegedly undesirable practical consequences of proceeding against the employees, it is fanciful to suggest that Nexus might have to join every affected member of its workforce as a defendant. To see the unreality of this suggestion, it is sufficient to note the history of the Anderson proceedings. The dispute about the correct interpretation of the letter agreement was conclusively resolved by the decision of the Court of Appeal in those proceedings. As we discussed below, the issue of rectification could also have been decided if Nexus had raised it. There is no reason why this issue could not be resolved in a future action between Nexus and a single employee or group of employees. And then there's reference to the possibility of a representative claim. So here the court recognises that these questions are ultimately intensely practical. And one is entitled to take into account, even if Avanci is not a party, of the inevitability, because of the position Avanci is adopting, that Avanci will assist Interdigital in defending the claim, in just the same way as the union would have assisted in this case. And it is not necessary, it was not necessary for Nexus to sue every employee who would be affected by the claim. It could take a test case against a single employee. And of course it happens all the time. Unwide Planet was a test case about the effect of the Etsy contract. Now, brought against a single defendant. Now, of course, there are a lot of critical differences between that case and this case, so I can't take this very far. I accept. Firstly, it arose in a very different factual context. Secondly, as I say, the union was not the agent of the employees and didn't negotiate on their behalf. So, whereas in this case, Avanci is the agent and does negotiate on their behalf. Thirdly, the agreements that the union could conclude were legally unenforceable, whereas Avanci concludes legally enforceable agreements. And fourthly, the claim was for rectification, which, as the court recognises, attracts a different body of law. But the principal significance, if any, is the recognition that the court is entitled to have regard to the practical reality of what will happen. And the practical reality here, as we know, is that Avanci will assist Interdigital. Indeed, it wishes to be a party. So we do say that the judge wrongly proceeded on the basis that if Avanci was not a party, then he had to examine fairness to Interdigital as if Avanci would not assist in the defence of the claim at all. And that was clearly a wrong approach that we respectfully submit. That concludes the second of 4 points I was going to develop in relation to Interdigital. I'm mindful that the court needs to stop at 12:55. And
how are you doing with time overall?
Tolerably.
Well, in which case, let's use the next couple of minutes.
My Lord, the third answer we say to the judge's reasoning is that he was wrong to be considering the arguability of the claim against Interdigital in isolation. The authority relied on by my learned friend is a case called Red October. I don't think there's time to go through it, but as the court will see, Red October, Authorities 1, tab 11, is concerned with the specific wording of Gateway 3. It does not decide, and my learned friend has not cited any authority for the proposition, that the court must ignore the full scope of defendants when asking whether there's a serious issue to be tried. And the fourth point I was going to make is that there is no unfairness to the other members in proceeding in the way we have proposed, because Avanci is well able to defend its members' relevant interests and has made clear that it intends to do so. If the claim does not proceed as a representative claim, which is the hypothesis at this point, then it won't bind the other members, but if they want to participate, of course they are at liberty to apply to do so. It shouldn't be necessary to join all 67 members any more than it would have been necessary for Nexus to sue all of its employees. And test the question this way: when ACER or the other claimants in the infringement cases, the members of the pool, bring infringement claims and say, I have made you a FRAND offer, therefore I can have an injunction, there's no suggestion that they join all 67 members of the pool, because the decision on their case might affect the other members, nor indeed Avanci. My Lord, I think I am now indeed.
Very good. And we'll pause there and resume at 2:05.
Court rise in favour.